My name is Xiang Yongxin. So here, my topic is about victims of trafficking in person should be prevented from being moved overseas. In year 2023, over 1,200 victims of human trafficking were officially identified in Southeast Asia. However, experts estimate the actual figure may be 5 times higher. Many of these individuals were not placed into safe recovery environments, but instead deported or moved again, often knowingly, into the hands of traffickers. Imagine surviving forced labor or sexual exploitation only to be re-trafficked because of the shortcomings of a very system that meant to protect you. As officers and policymakers working in immigration, your policies directly impact whether survivors are rescued or re-trafficked. While Malaysia has anti-trafficking frameworks, which is ATIPSO, in place, the reality is that loopholes in protection, misidentification, and legal uncertainty continue to place victims at a serious risk. I speak not only as a law student with academic training in migration matter and human rights law, but also as a fellow under the program held by Delegate Legal Affairs partnership with the International Organization for Migrations, which is IOM Malaysia, where I had the opportunity to observe these challenges in real time, especially in court as well as in the victims' shield. So I believe that my insights are grounded in both research and first-hand observation. Right. Now listen. Malaysia must urgently reform its immigration policies by introducing a victim-centered framework that aligns with the Article 9 of the Federal Constitution and complies with international obligations to prevent re-trafficking. I will now explain why. To begin, Malaysia's current legal approach is unintentionally exposing the victims to a further harm. So, according to the United States Department of Trafficking in Person report in year 2024, Malaysia did not consistently identify trafficking victims and continue to deport them without adequate screening. By referring to a public talk by PDRM officers from Bukit Aman's anti-trafficking unit, it was revealed that the police once proposed blacklisting non-trafficking victims in the immigration system to bar their movement overseas. Regrettably, these proposals was rejected by the Immigration Department due to concerns over violating Article 9 Clause 2 of the Federal Constitution, which states that no citizens shall be banished or excluded from the Federation. This situation reveals a serious policy vacuum. So the officers who are aware that the victim may be re-trafficked have no legal tool to intervene. According to Suhakam's annual report 2023, the absence of structured alternatives blacklisting puts both law enforcement and victims in a vulnerable position. So, in my humble opinion, this isn't just a gap, it's a form of state inaction. This constitutional safeguard in Article 9 must be respected, but respecting rights should not mean doing nothing when victims are at risk. We need lawful enforcement alternatives that give immigration officers the power to act responsibly. Well, legal limitations are not only the issues. Our structural systems also fail to protect victims effectively. Officers currently rely on the National Guidelines on Human Trafficking Indicators, which is known as NGHTI 2.0, which are rigid and overly technical. So many victims, especially undocumented migrants, do not meet the threshold set by those checklists and are first misclassified as immigration offenders. So according to the PIP report in year 2004, Malaysia heavily rely on strict indicators results in failure to identify victims in a timely manner. Suhakam adds that current immigration enforcement lacks victim-centered screening procedures, leading to a wrongful detention and deportations. So in my perspective, this is a double injustice. Not only the victims being denied protection, so they are also sometimes treated as offenders. Furthermore, traffickers have become adept at exploiting systemic weaknesses using fake documents, fraudulent job offers, and corruption intermediaries. According to the UNODC Global Report on Trafficking in Persons year 2022, traffickers thrive on weak border controls and fragmented law enforcement across Southeast Asia. This is also an alarming lack of coordination between immigration, police, and welfare departments. Those agencies often operate in silos, resulting in lost opportunities for early intervention. So in my view, even the best anti-trafficking policy will fail if it is not paired with practical coordinations and trust between agencies. So the frontline workers need streamlined tools and shared information, not just more paperwork. So how do we move forward? Firstly, while blacklisting violates Article 9 Clause 2 of the Federal Constitution, Malaysia could introduce court sanctioned protective orders or supervised relocation mechanisms. This would allow the court to restrict the movement of high-risk trafficking victims temporarily under judicial oversight and with proper legal representation. This balances the need to prevent re-trafficking risks with the obligation to protect the constitutional rights of a person. Suakat has stressed the need for legal alternatives and states that officers are currently placed in a position of inaction even when they foresee that the victim may be re-trafficked. Secondly, immigration reform must include expand access to victim rehabilitation service. This means that trauma counseling, shelter, legal aid, job training, not just for a few weeks but long enough sufficient to enable long-term recovery. When victims are released without support, they are far more likely to fall back into the hands of traffickers. So importantly, these reforms are not merely suggestions, they are legal obligations. According to Articles 14 and 16 of the Asian Convention Against Trafficking Persons, states that Malaysia must adopt victim-centered protection measures and ensure the coordinated action among all relevant authorities. Likewise, the UNODC guidelines on human rights and human trafficking year 2012 emphasize that anti-trafficking strategies must uphold human dignity to avoid re-victimization and include legal protection, shelter, and social service. So in my view, these international frameworks give us a roadmap. We just need to political will and administrative clarity to follow it. So in conclusion, Malaysia's current immigration framework leaves victims vulnerable and enforcement officers restricted. To summarize what I have said, current practices unintentionally enable re-trafficking due to legal gaps, and identification procedures are too rigid to catch victims early, and non-constitutionally valid protective tools exist for immigration officers to rely on. My call to the Immigration Department is this: introduce court-approved protective orders that align with Article 9. Reform the NGSTI 2.0 to allow for more flexible, trauma-informed victim identification. Establish a permanent interagency coordination task force to close the protection gaps. And these are practical, enforceable, and legally grounded reforms. They empower officers to protect, and not just the police, and they safeguard victims without infringing their rights. Human trafficking thrives in silence and systemic failure. Let us not become the channel through which victims are really trafficked. Reform is not only a legal responsibility, it is our shared moral obligation. Thank you.